Alright, this We the People News, not attorney, not giving legal advice, opinions only. Okay? Do your own research. Everybody's hearsay, so you must do your own research. Okay? Use the Second Amendment. Arm yourself with knowledge. Alright, so this is Eddie Craig on an interview with Joe Baker, Remedy Report. Okay? It's been a while since I've seen his videos. However, I kind of just went back and it popped up, and I was like, haven't seen him in a while, so I decided to check it out, and it was with Eddie Craig. Interesting thing. We've been talking about courts and this, that, here, and there, due process, and all that. But let's get a little bit more in depth by Eddie Craig. Okay? And remind you guys, this is Texas.
Well, eventually they put tire spikes in the road up in front of him. The Border Patrol did. Blockaded the road, drew their guns, and were drawn down on him when he came down the road to their position. So he stopped. They hauled him out of the van, threw him face down on the pavement, and arrested him and charged him with felony evasion. Forget the fact that the stop itself was completely illegal. Okay, that's what they want to avoid, is announcing that, yeah, we were trying to illegally stop a guy and he wouldn't stop. So Pat was forced into a case where they tried to get an indictment against him in secret in violation of Texas law, charging him with a felony without an examining trial, which is a violation of Texas law, and the judges were aiding and abetting the prosecutor in perpetrating an illegal prosecution. Why? Because, one, in Texas, there are 3 steps to getting a prosecution initiated. First and foremost, there must be a sworn criminal complaint, which no one ever made against Pat. There was no sworn complaint in Pat's case, ever. Once the complaint has been sworn out, there has to be an information file by the prosecuting attorney's office. That information must then be attached to the complaint, and if it's a felony, they are then required to send it to a grand jury for an indictment. But before they can get to the information or indictment, the initial step immediately.
All right. So this part is where they bypass a lot of the criminal codes. Okay.
Upon the filing of the complaint is the examining trial, where everything gets looked into by an independent magistrate. He looks into the allegation, the facts, the evidence, gives testimony from witnesses, et cetera, et cetera. And here in Texas, they have skipped all of that requirement for over 30 years. Even though it's written right into the law, it's got to be done, they don't do it. So,
they're ignoring most of it is ignoring criminal 14 and 15, which is with a warrant, without a warrant. Okay. To be taken directly to the nearest magistrate. They've been violating that. Period. Okay? You're not supposed to go to jail in Texas. And I'm led to believe other states as well. Innocent people's not even supposed to see jail, what it even looks like on the inside. There's got to be a step-by-step basis for you to be able to see inside the jail. Okay? Just saying. Alright, and then with that magistrate, that's going to be the guidelines under the Criminal Codes 16. Alright, and then you got the Criminal Codes, which is in the same section but a different statute. Then you got the Criminal Code, Transportation Code 543.003, I believe it is. Okay, when you're arrested, when you get pulled over and all that kind of stuff, you still got to go directly to the nearest magistrate. And you still got to follow the Criminal Code 14 and 15. Directly to the nearest magistrate. The magistrate must do the examining and basically find probable cause for you to go ahead and see jail. You're not supposed to actually go to jail first, get booked in, get fingerprinted, strip searched, and for you, some of you ladies, dig inside. That's supposed to be after the magistrate. And this is what they've been bypassing. And talked about in other videos, there's a couple of new subscribers, right? There's a man, well, actually, it's a woman bringing this up. A man's helping her. But they're in the process of suing appeal judges for gang activity for giving wrong legal advice, which is violating our due process here in the state of Texas, which is the 14, 15, 16, plus the other statutes that ties into this criminal codes. Just saying. Even tickets here in Texas, y'all, and some other states as well, but Texas, it starts off criminal. So everything really, a lot of deals is criminal. About the only time it's not criminal is if it's really kind of your township administrative ordinances and all that. Okay, that's a totally different section. You have to go into civil with that. You have to look up the statutes on that. Okay, but we want to get back into, because there's a statute, there may be 4 or 5 other statutes attached to that statute to get the whole picture. It's basically what your grandparents used to do when they did a crossword puzzles. You had to get a little bit of here, a little bit of here, because it applies to this one statute, even though them other statutes may apply to something else, but it branches off into a tree root and spreads out and attaches to other statutes. This is the reason why it's so complicated to go through the legal process. Okay? And they designed it on purpose so average men and women cannot come in there and be able to stand on their rights.
Helped Pat by helping him write up legal pleadings and get them filed in his case. And before he actually got to trial, they kept him in limbo for.
Let's go back there for a second.
Immediately upon the filing of the complaint is the examining trial, where everything gets looked into by an independent magistrate. He looks into the allegation, the facts, the evidence, gets testimony from witnesses, et cetera, et cetera. And here in Texas, they have skipped all of that requirement for over 30 years. Even though it's written right into the law, it's got to be done, they don't do it. So I helped Pat by helping him write up legal pleadings and get them filed in his case. And before he actually got to trial, they kept him in limbo for almost a year and a half, if not more. But we found.
Now, just so you guys know, when they're in limbo like that, what they are doing, okay, some of you guys have been in there, so correct me if I'm wrong. Once a month, the prosecutors, maybe even your court-appointed attorney, will try to go ahead and make you do a plea. Okay, if you decide to play not guilty, right? Well, they're going to keep you in limbo, and once a month, or maybe even every now and then, twice a month, the prosecutor is going to come in there and try to make some type of deal, some type of plea to get you to plea out. That's the whole design. And, you know, some of us get overexcited by sitting in the jail and just, or on bond or whatever. It's like, this is taking too long, right? At least in jail, if you get sentenced, it's counting time away from your alleged sentencing. Right? If you're on bond, well, you're out of jail, so it does not go against your alleged sentencing. Okay? Just saying on that. But that's what they're doing. They're holding it almost up to 2 years. Okay? There has been cases it's been 5 years. But they try to do it within the 2 years, and they may go ahead and drop your case. Once they do dismiss that, it's harder to do a lawsuit. It's designed to make it hard for you to actually do a federal lawsuit against them, or against the officers or whoever the wrongdoers are of the 1983. That is the sole purpose, is waiting towards the end of it to order to drop it. because everybody's got 2 years. If you don't have your ducks in a row, and the guy's been sitting in jail in there and don't have an attorney, well, he don't have enough time for an attorney to come in there and do all the research to do a lawsuit. And they know this.
Finally filed a motion to dismiss with the district court there, and both district judges that heard it were in on this from the very beginning. And in that document, I called out names, I called out facts, dates, times, every law that those judges, the prosecuting attorney, and everyone else had violated, and the case law from Texas that showed they cannot proceed from where they're at. And at that point, they waved the white flag and dismissed Pat's case in full. And they did it without prejudice, or they did it with prejudice, so they could never, ever bring it back against him again.
But there's 30 years of people who are victims of this kind of criminal stuff.
That's correct.
And they need to be they need some kind of remedy.
Yes, they do.
For all this that's happened to their lives.
Yeah, and you're right. And the problem is you cannot get that remedy from the system that corrupted the system in the first place. And here in Texas, we have this problem, and in every state, really. It's my personal opinion that if you look at all the facts and evidence, the problems of the Constitution not being complied with and the rule of law breaking down to the extent it has can be laid squarely at the feet of the bar associations and the attorneys that run them.
And I'm going to pause right there again. So there's a story, and some of you guys may or may not have heard, okay? But I'm going to say it. All right, so there's a bright young man and decided wanted to be an attorney and help out people. So he decided to go to college and all that, and he wanted to be the best at it. And he got high scores. He was on top of his class and all that. So he finally got graduated, right? So they did a big old celebration of the high on-road students of the law classes. And they rent this big building, or up on top of the very top floor, expensive room. And all the main attorneys are in there, the high dollar attorneys, you know, $50,000 an hour and shit like that. But they was looking for the best and the brightest to have them join their team. So the guy comes over, the top dog of the attorneys, come to the newbie, and he say, "Hey, come and walk to me to this window." So they walk to the window, and they do this on purpose, allegedly. Okay, I never become an attorney, was never high dollared, so I don't know if this is actually true or false, but it's a story. All right. So the main attorney told the new guy, "Look out this window. What do you see?" All right. Now I'm paraphrasing, okay? And the guy just says, "Well, I see the city and I see the lights and looks kind of peaceful up here." And the attorney says, "Well, you know what I see?" And the guy goes, "What's that?" Nobody down there can make any movements without us involved. Your towns has got to have attorneys. Your police station's got to have attorneys. All the people's got to have attorneys. All the federal government's got to have attorneys. All the FBI agents got to have their own attorneys. They can't move. Nobody can move without us. And with the guy that had character, turned around and walked out and decided not to be an attorney. So, well, let's finish this up a little bit.
They are the cause, the sole root cause of every single violation of the Constitution and individual rights and the creation of laws in every state that allow this kind of stuff to happen. And it's intentional. There's no way to look at it and think it's not.
The Bar Association stands for British Accredited Registry. I've heard. Is that true?
You've heard. It's not true. I've actually spent a long time communicating with some barristers over in England about this very issue. They actually agreed to help and do the research. They've never heard the term, ever. It doesn't appear in any English law or even an English history book. This is something that was cooked up by people that I have termed patronuts. Okay? They have patriotic intent, but nutty ideas and idiotic thoughts about how, and the processes as well, about how to fix it and how it began. They don't really read and understand things in a comprehensive manner. They'll read something, but what they get out of it is entirely different than what's actually written there when they learn to read it in the proper context. They'll read one thing instead of looking at the whole scheme of things it belongs within, its entire...
Right there, right? He's talking about the whole schemes. That's other things, other sections of law that goes into the one statute to kind of make everything work in a proper order.
Context. They will look at the one thing just like the courts themselves and the lawyers do, and they will isolate that from its surroundings and say, this is what it means because this is what it says. When in fact, if you put it back in context with all the things it's supposed to go with, the difference in what they think it says and what it actually says is worlds apart. It's not the same at all. And this is the biggest thing about what I try to teach on my show, is that when it comes to reading and understanding law, there is no one piece of law to do that. The statutory schemes across every state are written to function in the same manner. They are a mosaic. You will have one law in this code and one law in this code and a group of laws in this major code, which is basically the controlling code for the specific subject matter. And then you will have all these other codes that make satellite reference to or use parts of or integrate parts from that general code that applies to everything in depth. And those have to all be read as one complete body. And then you take that collective information and apply it to the specific facts and circumstances in front of you in order to properly understand what that law actually means and does. And this is something that attorneys and judges have gotten really, really, pardon